Good morning and welcome to the Law and Crime Network, everybody. This is Jesse Weber, and thanks for joining us today. We are entering into our 5th day into the case that we have been covering all week long, and now we are entering into our next week of this case. This is the case of Laquan Barrow, Michael Smith, and Gary King, the three-man second-degree murder case out of Florida. You've been following this all week. This is the case of these three men who have been charged with one count of second-degree murder in the shooting death of 19-year-old Benetria Robinson, as well as multiple counts of attempted second-degree murder. And this all stemmed from a nightclub shooting, a senseless nightclub shooting that resulted in the death of this young woman who had nothing to do with any of these three defendants. It seems that this all broke out as an altercation between two individuals, two young women that were associated with the defendants, and it broke out into a giant fight that brought itself outside and resulted in a shooting. And this young woman was just caught in the crossfires. We're entering into day 5. We believe the prosecution is going to rest their case this morning, and then it'll be up to the defense to put on their case if they decide to put on a case. But we have to dissect what we know so far and what we can anticipate moving forward. As always, this case has been starting a little bit earlier, so we might have a live feed any moment. As soon as we do, we'll make sure to go to it, and we will talk about that case in a little bit, but I have to preview another case that we'll be covering here on the Law and Crime Network. This is a case that many of you might have heard of. This is the case, it's a really sad case actually, of a young 15-year-old high school football player. His name is Xavier Dobson. Now, the reason you might have known this is there was a 30 for 30 documentary on ESPN about this young man. President Obama, in fact, spoke about this young man. Why? Because this 15-year-old boy, this brave 15-year-old boy, there was a gunfight, there was a drive-by shooting, and he jumped in the way to protect his friends, and he died as a result. Now, the three men who are on trial, do you see them right there? They're going to be on trial for the death of this young man, and we will be covering it starting tomorrow. It is really a case that's going to capture the nation by storm. ESPN covered it, multiple news outlets covered it. We're going to be covering the trial, and it's really a sad story, but it's a remarkable story about the bravery of a young teenager. So we'll talk about that case as well. But in the meantime, as we do preview the Barrow, Smith, and King case, I want to dissect what we know so far and what we can anticipate. And joining me right now is criminal defense attorney Jayne Weintraub. Jayne, good to see you again here on the network.
Hi, Jesse. How are you? Pleased to be here.
Good. So as we know, the prosecution is expected to rest their case today. You've seen what I've seen. You've seen a collection of witnesses put forward to the jury, some testifying that, majority of them testifying that Laquan Barrow was the shooter, some testifying to the fact that Michael Smith was a shooter or at least handed a gun to Mr. Barrow, and now new witnesses coming forward that Mr. King was in fact a shooter, although several people put forward by the prosecution couldn't positively identify him as a shooter or involved in this altercation. What do you think about the prosecution's case?
I think it's very, very weak and very, very sad. Anytime you have a multiple shooting, another mass shooting in the public eye or anywhere, it's just awful. I mean, what is our country coming to? So that's my personal feeling, but my lawyer feeling is prosecution really doesn't have a lot of evidence. What they did for 3 days is they put on all this gruesome and forensic CSI stuff about the bullets and the casings and the trajectory, which is the direction of the bullets, but they didn't have it going into somebody's hand into the gun. They just had bullets flying. So that really wasn't very helpful as far as who did this crime. You know, they have 3 young men on trial and they have to prove individually, not grouping them together, which is in their favor. Individually, the trial should be looked at for each defendant and separately. So what they have is, yes, they have some evidence, but they also have non-evidence. They have people who came in and took the Fifth Amendment, and one guy is in jail and sentenced to 6 months for contempt for refusing to testify. One of their best witnesses came forward and said, the police pressured me and made me say that, and he has a rap sheet as tall as I stand. And another witness came forward and said, I couldn't ID him at the time, but I can ID him now. I'll never forget that face. Well, I'll never forget that face is just such a quick, great lawyer line. I question if it was fed to him, but the problem is he didn't identify the person in the calm of the storm afterwards, just looking at pictures. So I think the prosecution is on weak ground.
The fact that you had these multiple witnesses and each was different in their testimony about what they saw and what they heard and who they thought the shooter was and who they thought was doing what, is that fair in the sense that this was a nightclub, okay? This was, not only was it loud, a lot of people are outside, but a fight broke out, and that adds to the confusion as well. How much is it for the jury that they're going to look at that and say, you know what, it was a crazy, chaotic scene. It's not fair to say that this witness saw one person as the shooter, this witness saw another person as the shooter. We're just going to take each witness for what they say. Or are they going to look a little bit skeptically at it?
Well, nobody ever knows what a jury's going to look at. The prosecution is going to hope that they see it for what it is. And, one of the old law school seminars in Criminal Law 101, it's on every single professor's lap. In the middle of a lecture, they'll have two people just run right behind the professor. One will take a purse or one will take a pen from the guy's podium. And the question is to the class, what did you see? Describe the two people that just ran behind me. And inevitably, you have 10 different descriptions of the same person because different people see different things. So it's one thing if it's a reasonable inconsistency. They didn't focus on what hand, the guy took the pen from. But you should know what hand the gun was in if you're really seeing that gun. Those are the kinds of things a jury should focus on. In other words, what's a normal inconsistency that somebody would be paying attention to? Remember, bullets are not something we expect to hear at a nightclub. It was chaotic, and that's the first thing that the prosecutor said in opening statement. This was a scene of chaos. And so I think, once again, we don't convict somebody in chaos. You're looking to deprive someone of their liberty for the rest of their lives.
Yeah, I want to focus on one defendant. I want to talk about Mr. King, Gary King here, okay? Now, he has his own separate jury, okay? He has his own separate jury. I've identified in this case, I feel, that there's a separate issue here, that you can say that there's pretty strong evidence against Mr. Barrow maybe, pretty strong evidence against Mr. Smith, but I don't really see it against Mr. King. What I see are two witnesses. We see two witnesses who have identified him as a shooter. One of them was a victim, okay, Nathaniel Kendrick, right, who said originally in his statement that King wasn't the shooter. Now you had a guy testify on Friday, Mr. Gerald Shaw, we couldn't play his testimony due to safety issues. He identified Mr. King as the shooter. To have only two people identify King as the shooter while multiple people could place him at the club, is that enough for Mr. King to convict this guy?
Sure it is. I mean, it's a very interesting take that you say that, Jesse, because I think that's very common. How many people do you need? How much evidence do you need? The answer is you only need one witness, one good witness. I mean, it's not a matter of amounts or quantity. It's a matter of quality. What did that one witness see? And what were the motives and the bias of that one witness? The jury instructions in Florida, when the judge is going to hand the case to the jury instruction will be, did the witness have, a stake in the outcome of the case? That's the exact wording. Did the witness have an opportunity to see what he or she is testifying about? Those are things that the jury is going to have to focus on. And remember, even that one witness didn't initially identify King as the shooter.
Yeah, I agree with you. I don't
think it's just to one of them. I think it's just to all of them. And I think King has the best shot of an acquittal, but I'm not so sure that the other two don't either.
Well, it is really an issue. You nailed it on the head. It's an issue of credibility. The defense attorneys, each one of them said, this is a case of credibility. Who do you believe? And I think they did a pretty good job of really diving into that credibility about the connections between the witnesses and the defendants. I mean, there was at least one witness who testified that he wasn't even entirely sure if he was related to Mr. King. He might have been his cousin. So it's interesting to hear that perspective. I do want to play for you and for our viewers cell phone footage of the fight. This is when Melissa Hall took the stand. And remember, this whole event, Benitria Robinson is dead senselessly because of a fight that broke out. So I want to show the viewers the cell phone footage of this fight. And then Jayne and I will be back to talk about the rest of this case as we do anticipate live testimony any moment. So let's now show... Welcome back to the Law and Crime Network, everybody. This is Jesse Weber. We are talking about the Barrow, King, and Smith case out of Ocala, Florida. This is the case. These three men have been charged with second-degree murder in the death of 19-year-old Benetria Robinson in a nightclub shooting called the Cloud9 nightclub. They're also charged with attempted second-degree murder, multiple counts of attempted second-degree murder. We're going to talk about that in a minute, but I also, for any of you who missed the earlier broadcast, again, we will be trying to cover this case as soon as we have a live feed in the courtroom. We'll make sure to turn to it. But I do want to let our viewers know that tomorrow we're covering a new case. It's the case of three men who were charged in the shooting death, another shooting death of a young teenager, 15-year-old Xavier Dobson. This young man risked his life, and obviously he jumped in the way of oncoming gunfire in a gang shooting. And these three men shot him, and this was a young, aspiring football player. He was featured in a 30 for 30 documentary on ESPN. President Obama spoke well of this young man, the heroism of this young man, and now those three men will be on trial. We will be covering that trial starting tomorrow. But again, we are anticipating a live feed in the Barrow, King, and Smith case out of Florida. I'm here today, joined with Jayne Weintraub to talk about this case. Jayne, one of the key aspects in this case is the charges. Now, they have been charged with second-degree murder. Now, I want to break this down for our viewers and try to understand this a little bit. From the accounts that we've heard, it seems that Mr. Barrow and Mr. Smith at some point went back to the parking lot to get the guns and eventually fire into this crowd, trying to kill Nathaniel Kendrick and his sister due to an altercation. Now, if that's the idea that the prosecution's going with and what the witnesses have said, that seems more like first-degree murder, that they reflected on it, that they had the intent to kill. Why second-degree murder? Why that charge?
I think that it was because they are aware of the weaknesses in the evidence that they have, and therefore they figured maybe they won't go for the highest. They'll go for the second degree, which is depraved mind, disregard for human life, which clearly it is when you're shooting into a crowd. Maybe they were thinking, well, the premeditation was to kill, but it wasn't to kill a specific person. That's the only theory that I can think of that they were trying to go by, because as you well know, premeditation isn't even just the act of going back and getting the gun. Premeditation could just take 10 seconds, as long as it takes to formulate the thought in your mind, I'm going to kill this person, and load the gun or pull your trigger back if it's not an automatic, then that's premeditation. It's not a matter of an act, but what you point out is absolutely true. Here you have so much more than the thought. You have an act, an overt act of going back, getting the gun. What else could they have been thinking than I'm going to go shoot that SOB? But I think it wasn't clear who they went to shoot. And so that may be why the prosecution opted to go for second-degree murder. Personally, I don't think that was the right move. And perhaps, although this is an awful thing to think of, but it is reality, many prosecutors charge first to get a plea to second. You've seen that over and over again.
Yeah.
They did not do that, much to their credit, because I guess they believed it was really a second.
Yeah, Jayne, this is really an interesting case on many levels. Actually, we do have our live feed now in the courtroom, so let's turn to it now, and when we come back, Jayne and I will talk more about the case. So let's turn to the live feed.
Instruction.